Hello ladies and gentlemen, thank you so much for clicking on this video. Epic Games, the creator of, I assume everyone's favorite game, Fortnite, is suing Apple, as in the actual Apple company, the $2 trillion corporation, I think now. This case has the potential to directly affect your life. I love this case so much because whatever the verdict ends up being, it will have massive consequences in the legal world. So this all started on August 13th, 2020 when Epic Games introduced into Fortnite Mobile their own version of a payment processing system. V-Bucks are the in-game currency of Fortnite, and you can buy V-Bucks using real-life money. Now, what Epic did on August 13th is that instead of making players use Apple's payment processing system, which takes 30% of the revenue, Epic introduced their own payment processing system, thus circumventing the Apple one and avoiding that tax. Epic Games called their payment processing system a competitive offer because it gave players the ability to buy V-Bucks at a 20% discount. Obviously, players were heavily incentivized to buy through Epic's payment processing system rather than Apple's. So predictably, a few hours later, Apple removed Fortnite from the App Store, thus preventing players from downloading any additional updates. The reason Apple did this is because they don't allow third-party payment processing systems. Apple claims that because of the safety and all the other features that the App Store offers, it deserves that 30% tax. Now, at the same time, Apple does not allow on iOS devices other versions of the App Store. It doesn't allow third-party app distribution stores. Now, on PC or computer, players can download games through any distributor that they choose, for example, the Microsoft Store or Steam or the Epic Games Store. On all iOS devices, Apple strictly disallows any other version of the App Store. So essentially, developers who create iOS games are forced to use the App Store, and because they're forced to use the App Store, they have to pay that 30% tax to Apple on all in-app purchases. Now, that specific number, the 30% that Epic Games is so adamantly against, has been a staple since the late 20th century, specifically with physical stores like Best Buy, Walmart, GameStop. Those retail stores from the beginning used that 30% number, and that 30%, as a result, has continued throughout the industry. Now, many people argue that the 30% was necessary for in-person or physical stores because in-person requires storage, it requires transportation. However, for online shops like Google or Steam, 30% might not be as necessary. In their store for PCs or computers, Epic Games has tried to highlight this by making their percentage not 30%, but actually 12%. So on the same day that Apple banned Fortnite from the App Store, Epic Games filed a very extensive lawsuit, essentially alleging Apple, in the iOS device market, you are a monopoly. So of course, we have to now deliberate what will be the verdict of this case. There's an excellent article on Gamesindustry.biz that I would highly recommend checking out. I used it while researching for this video. Epic Games is alleging that Apple is a monopoly. The single most important factor that will determine this case is, what is the market? In order to prove that some entity is a monopoly, you have to define the market that it is a monopoly of. So there are three different possibilities as to what the court could rule the markets are, and here they are. First, the market could be defined as all iOS mobile devices. 2, all mobile devices in the US, or 3, all mobile devices globally. The reason this case is so cool is because, from my knowledge, this is the very first time that the defendant of an antitrust lawsuit is the one who actually created the very market it is being accused of monopolizing. If Apple created iOS, then is the App Store really a monopoly on iOS devices if Apple was the one to create the entire market? So now let's go through the three different definitions, potential definitions. Let's start with number 1, if the court decides that the market is all iOS devices. This is the definition, the narrowest one, that Epic Games wants. They will easily be able to argue that Apple has a monopoly on the iOS device market because 1, Apple prevents other distributors from making their own app stores, 2, Apple prevents other companies from making their own in-app purchase processors, and 3, Apple imposes a 30% fee, which Epic will argue is unreasonable. If the court rules that the market is all iOS devices, this particular case will probably go down similarly to the Supreme Court case in 1992, Eastman Kodak Company versus Image Technical Service Incorporated, when they said that, quote, because service parts for Kodak equipment are not interchangeable with other manufacturers' service and parts, the relevant market from the Kodak equipment owner's perspective is composed of only those companies that service Kodak machines. Now, the court also ruled that this was a issue of fact, meaning it's case specific, not the law. However, if we rearrange a few words just from that quote alone, it could sound kind of similar to the specifics of this case. We could say, quote, because the services of Apple's App Store are not interchangeable with other developers' app distributors, the relevant market from iOS devices is composed of only those apps that service Apple. This case is also a bit similar to the Department of Justice's antitrust lawsuit against Microsoft. In that case, the court defined the market as, quote, operating system software for IBM-compatible personal computers. Given that narrow definition of the market, Microsoft at the time had about a 90 to 95% share of that particular market, so in the end, the Department of Justice successfully prosecuted. And the court indeed determined that Microsoft had a monopoly. Now, switching to the other side, if the court determines that the market is all mobile devices in either the US or the world, Epic Games will have a very difficult time proving a monopoly there. The FTC states that in antitrust cases, quote, courts look at the firm's market share but typically do not find monopoly power if the firm has less than 50% of the sales of a particular product or service within a certain geographical area. Some courts have required much higher percentages. So even if Apple owned, let's say, 55 or 60% of the market, this still in many courts wouldn't be enough to decide that it is a monopoly. Its actual numbers right now are, in the US, Apple has about 50% of the market share, and globally it has about 35%, so that would be a no way. To summarize, Epic Games has to hope that the court defines the market as all iOS devices, while Apple has to hope that the court defines the market as all mobile devices, either in the US, but more preferably for them, in the world. All of this action took place in August, however, there were a few updates in November. Apple actually filed a counter lawsuit alleging that on the day of August 13th, when Epic had its direct payment processing system, it actually stole funds or revenue from Apple. About a week ago, Judge Rogers, who is the judge presiding over this case, ruled that these claims of monetary theft were inadequate. Judge Rogers also said that this case should go to a jury, and if it does, it will very likely be dragged out to the summer of 2021. If you'd like me to keep you updated on the facts of this case, feel free to subscribe and leave me a comment telling me, please, enlighten us. I don't know, I find this case interesting, so I'll probably make a video anyway when something interesting happens, and especially when the verdict comes. We'll see what happens. Thank you so much for watching this video, and for now, I'll see you later.